Welcome back. Today we're going to talk about leases. So leases are that document. Remember when we talked about real property, there's a bundle of rights. And so one of those rights is temporary use of a facility. That's a lease. It could also be temporary use of a land. So a lease can be an hour, a day, a year, 10 years, 100 years, but it's giving the use of the land to someone else for a period of time. So a lease has to be in writing. Why? That's right, my legs. The L in my legs is related to land, and so leases in this context are related to property. There are three basic ways that you have tenancy. Tenancy for years. It runs for a definite duration. So don't assume it means a year or more. It could be a month. It could be you're renting a hotel room for a week. That can be a tenancy for years. When you do a Airbnb, that would be a tenancy for years. There's a definite start and a definite end, so there's a definite duration. A periodic tenancy is different because it's indefinite. It cycles. So it could be an annual, monthly, or weekly, but it's going to be based on that time period that you pay rent for. So the difference between tenancy for years and periodic tenancy is the fact that we know an end date. So a lot of tenancy for years start and then they'll transfer to a periodic tenancy at some point because it becomes automatically renewing and we don't know exactly when it's going to end. And then tenancy at will means that either party can cancel at any time, just like employment at will. We're done, we're out of here, goodbye, thanks for the memories, and moving on. So tenancy at sufferance happens when the tenant is no longer paying rent, but they haven't moved out. So they have possession of the facility, the land, but they're not paying rent. And so they're there against the landlord's interest, and that's a tenancy at sufferance. How do we terminate a lease? Usually by notice. So it may be contained and clearly defined inside the terms of the lease, or it's going to require that you give notice. So pay attention when you sign a lease as to when you have to give notice or it automatically renews. Sometimes it's 6 months, sometimes it's 60 days, sometimes it's a month, sometimes it's 6 years. So you really have to pay attention to your lease to know when it's going to terminate. You can also terminate it upon expiration. Periodic tenancy, it's going to be 30 to 60 days, usually at the end of a tenancy from year to year. And if the property is destroyed by a fire, a flood, things like that, then the tenants are usually going to be released or the rent's going to be reduced. So if you can't use the premises anymore because of the landlord's lack of fixing the house, the office space, after there's been destruction, then you don't have to pay rent. Fraud. If there's fraud because there are lies, there's an intent to provide misinformation, knowing that the other side will rely on it, then that can cause the termination of a lease and transfer the tenant. So if you know that you're going to be in an area for a limited time, but you don't know how long, you want to make sure that you can terminate at any point in time. Some people live in very transitory jobs where you're assigned for 6 months and then it might extend or it might cut short. And so if that's going to be important to you, then you want to negotiate that into your lease to have the flexibility to provide 30 days notice and then have the lease terminate. You don't have to use specific words normally, you just have to give notice. And then it can renew automatically. So if you fail to notice or fail to act on it when it's supposed to renew, that will be construed against you, not against the landlord. So really pay attention to those kinds of provisions. So what are some of the rights and duties of the parties? I'm so glad you asked. Here's what a tenant gets. They get the right of possession. They get the right to use that piece of land and any buildings on it for the duration of the lease, and they have the right to use it in what we call a covenant of quiet enjoyment, which means the landlord will not interfere with the tenant's use. They also have a right against constructive eviction. So think about a house where the sewage is backing up into the house. That's constructive eviction if the landlord fails to fix it upon notice. A case that used to be in the textbook, I think it's in the 22nd edition, talked about in a mall where a jewelry store had disruptions occur based on basically like a Best Buy type, we're gonna put subwoofers in your car, came in next door, and the bass vibrations literally shook the jewelry off the shelves. That could have been constructive eviction, except that the jewelry store failed to complain and then move out. That's one of the things that's critical about constructive eviction. If you're arguing that you've been constructively evicted, you're usually arguing that because of something the landlord has done or allowed, you can no longer safely live or utilize that space. If that's true, then you have to leave. Otherwise, you're not really constructively evicted. So if the use of the land is changed, then the landlord can declare the lease terminated. So an example of this would be a change in zoning. That may mean that you're no longer able to actually have the land still be used for residential. Now it has to be a commercial or a mixed-use space. So in that case, the landlord has to change the use of the land, and that would terminate the lease. Tenant is ordinarily required to give notice of non-use, and a landlord can restrict pets because pets can cause damage actually pretty easily to a place. So that's something that they can do. The landlord has a right to have the rent paid on time and not to have the tenant assign the use of that facility without the permission of the landlord. And we'll talk more about that in a minute. Also pay attention, there could be a clause in the lease that allows for the rent to escalate over time. It means it can increase over time. And if that's in there, the courts will enforce it. All right, the landlord also has the right to inspect the premises for emergencies or notice of repairs. So an example of this would be we came home one day and there was a puddle of water on our comforter, and our mattress was ruined because there had been a leak in the apartment above us. And so in that kind of situation, the landlord can come in without permission to make sure that there hasn't been harm done to the apartments near and around. And the landlord has to comply with all federal laws and local laws. The landlord has given a warranty of habitability that they will make basic repairs and that the facility will be free from structural defects. And rent can not be due while you can't live in it because of repairs being made. Neither party has a duty to make improvements unless the lease states so. So often what will happen in a commercial sense is that the tenant will make the improvements and then the improvements usually will get left. If you think the landlord should make them, make sure that the lease reinforces that. And then the landlord's generally responsible for taxes and assessments, but I have seen quite a few commercial leases that put this burden on the tenant. So make sure you know which is happening in your situation. What can a landlord do if the tenant fails to follow through on what they're supposed to do? They can get a lien on the agreement or to personal property, but only if that's included in the statute or in the lease itself. And they can also sue you for rent that is owed. So they can collect that overdue rent. And then they can recover possession. So you can't lock a tenant out for overdue rent in most states, but if they leave, you can reclaim the access to the facility. And then they have a duty to mitigate damages, and I'll talk more about this in class and give you more examples. If someone is injured on the premises, the landlord is liable in certain circumstances. If they knew about the problem, then there may be liability when the tenant is harmed by a third party who commits a crime. And they may have tort liability if they know about the danger on the property and didn't do anything to correct it. However, leases will often include a provision that provides indemnification of the landlord. So if the landlord has to pay for any injury that occurs on the premises, they can then come after the tenant to compensate them for that loss. And the landlord is not generally liable to third parties unless it's in common areas. So once they've turned over possession and use of the, let's say, apartment or the commercial space, landlords generally aren't liable to third parties unless somehow inside the lease they kept that, which it wouldn't be normal. And the tenant is liable to licensees and invitees for failures to do due care. This should sound an awful lot like what we covered in the tort chapter. So liability insurance is a really good idea to protect yourselves in the event that a third party is injured. Okay, so here's really the last thing in this chapter. So let's use yellow this time and see if it shows up well. So you've got the landlord and the tenant. There we go. And they're in a contract. You've got the lease. So the tenant wants to get out of the lease because maybe they're going on study abroad. And so they're not going to use that apartment for a semester. And so they don't want to just pay that rent without getting the use of it. So you have the options of an assignment and a sublease. So assignment gives basically the new person everything that the original tenant had. They get the full use, the full ability, but a sublease only transfers part of it. So with an assignment, the new tenant basically comes and stands in the place of the tenant. So in a lot of ways, the original contract goes away, and now there's a new contract here between the landlord and the tenant, or the assignee. So now let's look at what it would look like in a sublease. So in a sublease, you've still got, whoops, I guess I need to change back to this. You still have the landlord in a contract with the tenant. The tenant wants out, but now they're subbing, and that means they're giving part of their rights. So let's say I've leased commercial space and I have an empty office. So I sublease the office. So now there's a contract between me and the sublessee, and there's still the contract between the landlord and the tenant. So I am still in this contract. I can't go away. I don't get rid of my legal liability, but I now have a second contract with the sub. And so that's the basic difference there. So you can't give away more rights than you already own. And an assignee is bound by the original lease, but a subtenant is not. All right. In both of those, though, the landlord's going to want you to be on the hook. You can think of yourself as a guarantor, that if the new tenant doesn't do what they're supposed to, the landlord's going to come after you because they're still going to get paid. All right. That's property. You now know as much as you're going to learn in 254. If you want to know more, go to law school.